Hello friends, what are 5 types of writ petitions? Do you know that filing writ petition is your constitutional remedy and your fundamental right? One of the fundamental rights is right to avail constitutional remedies. So it's part and parcel of that. So now coming back, there are 5 types of writ petitions which you can file either in the High Courts or the Supreme Court of India. So the number one is writ of mandamus. This will be filed against the government or public authorities whenever you want to challenge some kind of arbitrary actions that have been taken against you. So this is what is called writ of mandamus. Even if you want to file a public interest litigation, then also like you will go for a writ of mandamus against the authorities. Now comes the second writ. Second writ will be writ of habeas corpus. This is a writ, like habeas corpus means producing a body before the court of law. So if somebody is illegally detained or like abducted or kidnapped, whatever, like missing, so the police is not taking proper action, then you can invoke this particular writ called writ of habeas corpus, either in High Courts or Supreme Court. Then comes writ of quo warranto. If anybody is holding an office, a public office, without any proper authority or illegally or unconstitutionally, you can challenge his post or appointment by filing a writ of quo warranto, and his position or his holding of the position will be quashed. And number 4 comes writ of certiorari. Certiorari is a writ where, like, if the trial courts or the subordinate courts commit some kind of error, then in order to correct that, writ of certiorari are issued against them, more like an appeal. Then comes writ of prohibition. This will be used if at all the courts are committing any errors, the trial courts or the subordinate courts, they are committing any errors. Then in order to further stop them from committing further errors, this writ of prohibition can be issued. So now these are the 5 types of writ petitions which you can always avail as a fundamental right by invoking the jurisdiction of either Article 226 in the High Courts of Judicature, or else like under Article 32 directly in the Supreme Court of India. But there is a small catch here. If at all your fundamental rights are getting violated, then only you can invoke the Article 32 in the Supreme Court of India. But if at all your legal or constitutional rights are getting violated, you have to first knock the doors of the High Court, then only later stage you can challenge the adverse orders in the Supreme Court. Directly you cannot invoke the jurisdiction of Article 32. Thank you friends.